मेरे व्हाट्सएप पे रख दो सर एक बार। यूट्यूब में म्यूट करने का
Prepare कर
stream YouTube
इधर
उसको देखने में
सबको
Hello. Hello. Very good morning to everyone. We're sorry due to technical error, we had to change the login details at the last moment. Hope all will be joining within 5 to 10 minutes. Um, I think I'm audible. Am I audible? Yeah. Very good morning to everyone. We're sorry due to technical error, we had to change the login details at the last moment. Hope all will be joining in 5 to 10 minutes. I think I'm audible.
Yes, sir.
Very good morning to everyone. We're sorry due to technical error, we had to change the login details at the last moment. Hope all will be joining in 5 to 10 minutes. So we'll start the program. Goda sir, welcome. Am I audible, sir?
Yes, sir.
Yes, sir.
I'm hearing.
Yeah. Very good morning and a warm welcome to all the participants of the national webinar on intellectual property rights and its awareness in India. I'm sorry for the inconvenience due to technical error. You had to log in again. And some will be joining very soon, I think, if they have not received the communication on time. I am Dr. Punacha. I am Director IQAC, Sumandeep Vidyapeeth, and I would like to give a brief introduction on today's program and also introduce the speakers in brief, and the detailed introduction will be done later. So, to speak about IPR or intellectual property rights, intellectual property, as you all know, refers to any intellectual creation of mind, and intellectual property laws give people the right to own and profit from their artistic, scientific, and technological creations for a designated period of time. The various forms of intellectual properties, which includes patents, trademarks, copyrights, industrial designs, geographical indications, other types of designs, trade secrets, etc. And the intellectual property protection has become
Sir, you're mute.
and the IP protection is mainly formed to prevent infringements of registered invention from others. And failure on adequate protection of intellectual property slows down innovation and progress overall. And an effective IP or intellectual property protection is essential in order to promote R&D investments, appeal to foreign capital, and encourage innovation. And finally, the various guidelines and regulations, government regulations and acts, and the goal of these laws is to encourage intellectual production, promote them, and also to enable social and cultural development overall. Examples of these are the main acts in India, which includes Trademark Act, the Patents Act, the Copyright Act, the Designs Act, the Geographical Indication of Goods, Registration and Protection Act, the Protection of Plant Varieties and Farmers Act, and the Information Technology Act. I think the speakers will be speaking in detail about this, or will be giving an insight into these acts. And IPR at Sumandeep Vidyapeeth, to say we have a dedicated IPR cell under the Department of Central Research and Innovation, and separate IPR policy exists to facilitate researchers and inventors. And they regularly also conduct from the cell the various training and capacity building activities And IPR cell also monitors all IPR related activities in the institution and maintains the data and records. I'd like to say, as we are in a healthcare based institution, so we need to throw more insight into these areas, and we need to evolve further compared to the technological institutes or institutions. From today's session, we may be able to learn particularly from that healthcare point of angle, and it would definitely enrich audience. And at the end of this program, I hope the participants will be able to understand and appreciate the potential of protecting the inventions and creations, existing government policies, and support for registering the inventions and creations under various heads, the process of filing copyrights, patents, trademark, etc., and its duration of validity. And I feel this point would be of considerable importance, because many do research, they innovate things, but they may not be knowing what exactly to do, how to file a patent, a trademark, a copyright, etc. Again, I hope they will be, all the audience will be enlightened again on these aspects particularly. And also they would be able to update oneself with latest development in the field of IPR. So coming to the introduction of our esteemed speaker, I will be giving only a brief introduction. Dr. Medha will be giving a detailed introduction. The esteemed speaker and Dr. Sharan Gowda, he readily accepted our invitation. He is a diploma in IPR and yes, LLB degree, which complements this field, and also he is a PhD holder. He is currently working as assistant controller of patents and design, and also heads the biotechnology group at Patent Office, Chennai, and the Government of India. He would be talking on protection of IPR in India. And sir is there. Welcome, sir.
Thank you.
The next keynote speaker is Dr. Shivogi M. Hugar. He is a professor and head Department of Pediatric and Preventive Dentistry, KLE BK Institute of Dental Science, Belgavi, Karnataka. He's a very good friend of mine, and he has also worked a lot in that area. He has a 10 patent under his belt, and also he has guided around 75 patent filing in the last 5 years. He's a very astute academician, and post lunch he will be taking the session on scope of patent filing in health sciences. Next, the keynote speaker is Dr. Anshula Deshpande. She is done her MDS, MBA, and also she holds PG diploma in IPR laws from National Law College, Bangalore, which is a reputed law school in India, and she also has a PhD in education. She is also secretary of IPR cell at Sumandeep Vidyapeeth. Though she is out of station, but she will be covering the session from wherever she is today. And her topic will be copyrights and designs in health sciences. So these are the speakers for today, and I hope all the participants would be greatly enlightened after this session, this days of program in IPR related things, and they can also interact with the speakers. I welcome all the delegates again, and thank you. And I ask Dr. Medha to introduce our keynote speaker, Dr. Sharan Gowda Patil. Thank you.
Thank
you.
A very good morning to everyone. On behalf of IQAC, I welcome all the participants in the national webinar on intellectual property rights and its awareness in India. I welcome our first keynote speaker for the day, Dr. Sharan Gowda. He would be speaking on protection of IPR in India. Sir is PhD in biochemistry and is also LLB diploma in fostering innovation and commercialization of IPR from CBS Copenhagen, Denmark. Sir is specialized in examining and scrutinizing the patent applications based on traditional knowledge-based inventions. He has a professional experience as a coordinator for the Patent Office, India, and National Biodiversity Authority, India, member of Expert Committee on ABS of Biological Diversity Act 2002 since 8 years. He has 18 years of experience in Patent Office India and 3 years of experience to teach MSc Biotechnology, Biochemistry and Biotechnology course. Sir has 7 publications to his credit and has also received the reputed Young Scientist Award from NESA, New Delhi. He has delivered more than 200 lectures at various universities, institutes, companies, and colleges on patent system of India and its role in development, and also on IPR along with biodiversity issues. We welcome you, sir.
Thank you. Thank you, ma'am. Can I start?
Yes, sir. Sure, you can start. Yeah.
Thank you. First, it's good morning to everybody who are all joined here. So I take this opportunity to thank Sumandeep Vidyapeeth and specifically the IQAC cell of Sumandeep Vidyapeeth and Dr. Punnacha sir, so for giving me this opportunity. It's a great privilege to share with you all my experience in the field of intellectual property rights, specifically on patents. I'll be giving details on patents and how one can obtain the patents. So in all, I will cover with the topic the 6 IPRs. So 6 prominent IPRs, which our office, the Controller General Office, are along. There are several different offices within the Controller General's office: Patent Office, Trademark Office, Copyright Office, then Industrial Designs Office. So I'll be giving as Punacha, so Dr. Punacha was giving the thank you, sir, for giving a brief on intellectual property rights and its importance in the current scenario. So I'll be taking on from there. So what is the intellectual property rights? I'm here sharing my slides. So can you see my slides, sir?
Yes, sir.
Yeah. So first, moving on to what is intellectual property right. So before that, we'll have to start from the central theme of this intellectual property right. This is a combination of 3 words, in that the central is the property. So what is property? We all know what is property. So it's everyone in India or abroad, so they know about what is property. So property can be broadly classified into 2 classes. One is the tangible, which you can see and touch and experience. In that, again, you have movable tangible property and immovable tangible property. So these properties, which are tangible in nature, we know all about these properties, whether it is a building that is a immovable property, or the vehicles, which are the movable properties. So we are not much concerned with those properties which are tangible in nature. So today's topic, I will be mainly dealing with the one of the intangible property, which you cannot see by your eyes and which you cannot touch and experience. What is that property? If someone asks what is the you have IPR, so you cannot show it. So that type of clause in that intangible is the one of that intellectual property. So intellectual property, when you get a right, that is the legally your enforceable right you have, then we call it as a intellectual property right. So in that intellectual property, again you have broadly two classes, that is industrial property and the copyright and related rights. So in industrial properties, prominent are patents, industrial designs, trademarks, geographical indexations, and SICLD. So I'll deal all these industrial properties one by one. So in today's, so first, what is intellectual property right? So we know property, and what is intellectual property, which we abbreviate as IPR. So one definition we can give to this is a creative ideas and expressions of the human mind. Human mind, we call it as a intellect, that have commercial value. This is most important. See, any creations, a human from the birth to death, so you may create so many creations. In that creations, and he may be getting the lot of ideas. See, a lot of people, more than 50 people have joined the lecture. So overall, by sitting here, you may be getting so many ideas. So, but ideas, you have to express it. So practically you have to express it something. So on that expression, not all ideas which you have expressed may not be having a commercial value. So that's why they may not be called as a IPRs. But here in ideas which you are getting and which are expressed by your mind, the human intellect, so that have commercial value. So those expressions with a commercial value, so they can be called as a intellectual property. And when you get a enforceable right on them in your name, so then they will become intellectual property rights. So that is IPR. So what are the characteristics of this IPR in comparison to the tangible property rights? So all this, whatever the name we call IPR, they're all negative rights. It means they are not giving any positive right. Positive right means if today I buy a car, I have to register to drive on a road. So this gives a positive right. But here intellectual property rights, which give the negative rights. It is right against others, to restrict others at the commercial place or marketplace. So these all IPRs, they are all negative rights, and these are all exclusive rights. Whoever gets a right, so he can enforce against others exclusively. So that gives an exclusive or monopoly right. And one of the important characteristics is they're all territorial rights. Whichever the country you are getting this right, so in that country only you can enforce them. Say, for example, if I get a patent from Indian government, so I cannot enforce that in United States of America. So I need to get in US office, patent office, then I can enforce in that country. So it is vice versa. So wherever the country gives that registration or grant, so in that country only you can enforce it. So that is why these are all territorial rights, and these are licensable rights. So this is the common feature with the tangible and intangible properties. So you can license it, mortgage it, or sell it, or assign it, anything which you can do with the tangible property, the same things which are available with the intangible properties also. So these are the four important characteristics of a intellectual property rights. So these are negative rights. Then you have a monopoly right. This is created by you, so hence it will be a monopoly for you. Territorial right, and it is the licensable or assignable right. Now, what prominent are? So patents, designs, industrial designs, that is trademarks, geographical indication of sources, and copyrights. So now why are we here? So as Dr. Punacha sir has said that there is a requirement of a awareness. So here one thing is awareness is about the research. We have a lot of awareness we are creating. We Indians are doing a lot of research and publications, but we are at the same time lagging in converting them into a monopoly rights and encashing them. So here intellectual growth, what Einstein has said, that intellectual growth should commence at birth and cease only at death. So this is all intellectual creations are from birth to that happening, but their monopolizing is the requirement. So in that we are lagging the lack of awareness. So because of that, see, if this slide shows you global innovation index, that is every year it will be published by the World Intellectual Property Organization, WIPO, situated at Geneva. It will publish every year. So what this GIA in 2015, India was at the 81st rank, and in 2021, so we almost moved around 50%, we up to 46. So we are moving in innovation index. We are in 2015 at 81st place, and we are now at 46th in among the all countries. But if you see the research, whatever it is happening, that research means it is the innovations. And why we are lagging? Because the protection we are lagging. Awareness at the protection of the intellectual property rights is lagging. We are none to second in research, but we are not having awareness sufficiently at India. So that may be the one of the reason we are still not in a top 10. So hence our Prime Minister's dream is that Honorable Prime Minister Narendra Modi wants we to be in top 10 in the Global Innovation Index. So that's why we have started with the National Intellectual Property Awareness Mission, and on the part of that, so this is the one of the awareness mission program we are holding with Sumandeep Vidyapeeth. So thanks to organizers of this program, and I hope this will give the participants the awareness on the intellectual property rights. So first, among the intellectual property rights, as I said, these are intangible properties, and these are having a characteristics of territorial, exclusive rights, and negative rights, and the licensable rights. So this one of the important intellectual property right is the patent. So what is patent? If you see in the word patent, 6 letter, if I put I, it will become a patient. So it will be a so much similarity with that name. So maybe health sciences may all aware of that. So this patent I can define in any way. So one of the definition I have written for you all: exclusive privilege given to the privilege, I am saying, or right, you can say, given to the applicant. So yeah, exclusive privilege or right given to the applicant by the government for a limited period. So who will give this right? It's the government of any nation. It can be. So if it is in India, It's the government of India, and it is for a limited period. So the right given is for the limited period. It's not for unlimited period. So patent is for only 20 years from the date of filing. That limited period is 20 years. It is if anyone files today on 15th July 2022, its expiry date is fixed. That is 15th July 2042. It's a 20 years term will be calculated on the day of filing a patent. So it gives, as I said, all IPRs are negative rights. It gives to exclude or prevent others from making, using or selling the invention without permission. So without permission or without license, you cannot use for making, using or selling. That is commercial purpose. In return to the complete disclosure of the invention. So what you have to do to get the 20 years exclusive right, you need to disclose completely to the patent office. In turn, that patent office will publish in the website, that is in patent office journal, so that the public will come to know that so and so person has invented so and so invention. So that is how it gives the monopoly right for a complete disclosure of the invention by a person or researcher or inventor or applicant. So these are the some terminologies we use. So inventor invents, and either he can apply or he can assign it to anyone for application. For example, if the researchers in the Sumandeep Vidyapeeth, they can assign it to the Sumandeep Vidyapeeth. Sumandeep Vidyapeeth can be a applicant, and when it is granted to them, it will be a patentee. So this how it is. A applicant will get a 20 years exclusive right to prevent others from for commercial purposes. That is, and if this enforcement is all will be happening through the civil suit. So no criminal in the patent. So anyone can enforce this through the civil suit. So that is how it will be working to enforce against the others. So in simple terms, what is patent? For a complete disclosure of the invention, you will get exclusive right. Whoever discloses, they will get exclusive right for a 20 years for preventing competitors at marketplace. So that is what in simple terms what is patent. So if you see, the role of patent system or IPRs, what they will play for our scientific community. So first and foremost, everyone, whoever invents that, they will give their application, their invention as application to the patent office. Patent office will publish at one place in the database. So that will become the science and technology database. For the future generation, the information will be fully protected and it is stored. So it gives an encouragement because it is giving a 20 years monopoly right. It gives an encouragement for improvement of the existing technologies, and by that way it gave rewarded, the inventors are rewarded in the form of an exclusive right for 20 years. It's a huge right if you think of that. So 1 against 1.32 billion population, if anyone X person is Indian filing in India, so and he is getting a right against 1.32 billion population, so it's a huge right rewarded to him, and he can sell the invention after patenting. He can assign it, or he can get a royalty by assigning it or by selling the invention, and put, or he can put a one company. Nowadays many are making a startup companies and they are encashing that, so they can put into practice. Or the for a government perspective, So once 20 years period is completed, so the invention or the research will become public property. So everyone can freely use that property for the commercial benefits. So this is the role of patent system it plays. So other important advantages of this patent system existence is avoids duplication of research. So knowingly or unknowingly, many researchers, if they are not publishing at one place, so there may be a duplication, triplication of the same research may happen. It can be avoided, and says latest developments in the field, it can updated, and it helps to industry produce a cheaper and better products compared to the price. Cost effectiveness can be increased by fair competition. It serves as an indicator. So today we may say by that, so and so institute has so many patents. So that serves as an indicator for the research excellence of that institute. And the last but not the least, it's the important that it records the information for future generation. So once you are giving a patent application to patent office, there may not be a loss of information to the future generations. So your information is protected and kept in a properly searchable format in the patent office records. So that will be a information for the future generation. That's what we say. So our ancient past was having a lot of information on Ayurvedic, Unani and Siddha. Today we may have lost because they were not recorded at one place. So that should not happen for our researchers who are day and night doing a research and producing a lot of inventions, and that should be benefited for our scientific community, and in future it should not be a information loss. So for me, this is the most important aspect of the patent system. Now coming on to the some, I'll just from the Google I have taken. This is not for advertisement. So this is just for showing that some of the inventions which rewarded huge to the inventors. One inventor who has invented a simple form of that is a ring pull can. So very, very simple. Such type of inventions may be occurring around us everywhere. But what is the lack is that they are not realizing their potentiality of their inventions. So that's why we are not protecting and we. So here one inventor who has protected this ring pull can. This is a very simple to open the can. So he has made a one ring so that you can open, make a easy opening of that. So everyone might have seen this ring pull can either on the cola bottles or this. So Coca-Cola company was behind him to take the rights from him, but he never assigned that invention. So he has just gave a license for the 1/10 of whatever the profit Coca-Cola gets from that Coke selling. Yes, by that he has earned for 20 years on an average 1.2 crores per day. See, it's a huge. So per month it is around 40 crores, and per year it is maybe around 400 or 500 crores. So it's a huge. So not all inventions may reward this much, but there may be a, if the market accepts that invention, there may be a potentiality for those inventions. But assume that if that inventor has not patented this, he would not have got out of that, because if he simply published in a journal, everyone would have been enjoyed that. So they would have been copied and nothing should have been rewarded to that inventor. But here he has anticipated the potentiality of his invention for the commercialization, and that's why he has been rewarded handsomely. So this is what that simple inventions, but you need to properly protect it, and then you will get a reward. And others, if you see, there are around 400 patent clips. So patents for a clips, a simple clip what we use day and every day. So those clips, there are around 400 paper clip patents which were sold for a 535 crore Indian rupees. So it is, if someone says in India, so we have invented this paper clip, so we may laugh at them. Oh, what great you have done, what noble work you have done, like that. But patent is not for the great things only. It is for the even simplest of the simplest, like the paper clips. You can, if you show inventiveness in that, it can be a patentable one. So only you have to know that. So what is the technical advancement and what is the advantage of this to the society? So if that is there, you can just patent it. So because why I'm saying these are the very simple inventions, maybe past inventions, but these are very simple. People have protected them properly and they have enforced them. And this is also a one spin brush. This has been sold for to the Procter and Gamble for rupees 3,000 crore. 4 inventors who invented this spin brush, that is battery operated brush, toothbrush. So I think all dentists might be knowing this. So this is also an invention, so which has rewarded huge. Simple invention according to us, there is no complex, but it has rewarded a huge. So in crux, what I just wanted to show with these examples is that, so whatever the invention, whether it is small or big, contribution over the prior art, which you can protect it in any form. Only thing is that you need to show that the advantage over the existing technologies. If there is an advantage, so and that advantage will constitute a inventive step and it can be protected in India. So if anyone invents in the Sumandeep Vidyapeeth, so how they can file a patent? So what are the requirements of filing a patent? So first and foremost, there must be an invention. You must have to research it and have to invent and something, and then only you can think of patenting it. So what is invention? I'm sure that our researchers are doing a lot of innovations and inventions. So according to the Patents Act 1970, what is invention? An invention means a new product or process involving an inventive step and capable of industrial application. So there are 3 aspects you need to remember for everywhere. These are the 3 fundamental criteria which will define the innovation or invention. So first and foremost, in India, we protect, or you can protect for any new product or new process. That is, new product or new process for making that existing product or new product. It can be. So which must involve an inventive step, and it must be having some industrial applicability, capable of industrial application. So the 3 criteria which are there as novelty for a product or process, whatever you are creating, it must be a new process or new product. It must involve an inventive step and capable of industrial application. So these are the 3 criteria which will decide whether you have invention or not. And what is the novelty? Novelty, we know everyone about the novelty. So that is, the new means it should not exist before that date. Before that date means here before the filing date of a patent application. So today, if someone files a patent application at patent office, that is on 15th July 2022, whatever there in the public domain till 14th July 2022, till 14th July 2022, everything it will become a prior art or state of the art. for your invention. Regarding that invention, if anything is published, exact true copy of that product or process is published, then we say it is not new. If nothing is published as far as the research, what you are claiming as a product or process, if it is not there in the prior art or in the public domain, then it will become new or novel. So once you establish the new or novelty, so then we'll move on to the determination of an inventive step. So what is inventive step is, it means a future of an invention that involves a technical advance as compared to the existing knowledge, or having economic significance, or both. It can be technical advancement as well as economic significance that makes the invention not obvious to a person skilled in the art. So either you might have made a technically advanced thing, product or process, which is over the prior art, over the existing technologies. You have created something, a new product which is technically advanced. So that technical advancement is giving you the advantage of over the prior art. Whatever the advanced, it can be anything, it can be, for example, you have made a drug, so which is advanced, or which is advanced over the existing drugs. So that will give advancement. So that advancement will be called as a technically advanced one. So that technical advancement may also have a economically significant one. So it is a generally process will be assessed with the economic significance. Like I have process, one has developed a process which is, there is a existing 4-step process to make one drug or one chemical, new chemical entity, or it may be an existing chemical entity. So if someone develops a 2-step process, so then it definitely, it is a time saving and resource saving, and it will be economic significant. So there can be a both economically significance as well as technically advancement, or either of one. So which should not be obvious to a person skilled in the art. So what is person skilled in the art is, it is an average knowledge person. Neither he is a PhD holder in that field, or he is not a illiterate. So average knowledge person should not have obviously made this product or process. So if that is there, then it can be told as inventive step involving. So involving inventive step means it's a technical advancement over the prior art, or economic significance over the prior art, or it can be combined economic significance as well as the technical advancement that is not obvious. Obviously, he cannot make this, then it is involving inventive step. So generally, the determination of inventive step is bit a complicated process. It's not what I am explaining. It's not that much easy, because it depends on the number of prior arts we are analyzing, and over that how I can take. So, but you need to show that some advantage over the prior art. If there is advancement, if there is advantage, then we consider that as a advancement, and that will be rewarded a patent. So in short, there should be a advantage over the prior arts. So then it will be a inventive. The third criteria is industrial applicability. So what is this? This generally in patent office we never object. In 99.99% cases, every invention will be having a capable of industrial application, because it is a broader definition. What it says in relation to an invention means that the invention is capable of being made, or used in an industry. So either it can be produced in a large scale in industry, or it has a utility in any industry, like it may be in pharma industry, it can be in health science industries, or it can be FMCG, it can be any type of industry, it might be having a utility. If that is there, then it is sufficient to say that there is a capable of industrial applicability. So these are the three criteria. So for example, I have developed one product. So I just through the Google, I checked that. So it is not there in the prior art. I am not getting any reference for that product. And it is advantage to the society over the existing one. Then it is having a applicability in health sciences industry. So then you are having an invention. But anything you have invented, a product or process, so if you want to file outside India, say for example in US, so these are the only three things you need to look into that. So you need not bother about the other sections of the Patents Act. But if you want to get a right in India, you need to check with the section 3 A to P and section 4, because India has a lot of restrictions for the patenting activity. Within that only you can patent in India. So unlike in other countries like US, so we are having bit restrictions from our parliament. So some of the categories of the inventions, though it is novel, inventive, industrial applicable, but we are not granting a patent for those things. So what are those? So if someone comes with a frivolous or perpetual motion or an invention which is against the naturally laws, science laws, whatever we have studied, if it is there, so then it is, we treat that as a frivolous or false. So those so if you are establishing that practically, then it can be rewarded a patent. So if any invention which is against the public order or morality, so if it is immoral or against any law of the land, for example, if someone comes up with a invention for determination of the sex of a fetus, within 8 weeks we can determine. So many inventions which are patented in US, but if someone comes up for that patent in India, so then it may not be given a patent because it's against law of the land. Any law which is there, we have a law. So against that it is. Others, so only inventions are patentable, not the discoveries. In India, we are not granting any patent for the discoveries, because though if any chemical or microorganism, if anyone wants to patent it, it is already existing in nature, we treat that as a discovery. So no discoveries are patentable, only the creations, that is. And in pharma case, a new use of a known substance, for example, if something is known for one disease, this will be a new property for using for the other disease, so you cannot patent it. So new use of a known substance or new form of a known substance also without therapeutic efficacy, you cannot get a patent in India. So admixture, if anyone comes up with the A and B mixture and he has to establish the synergistic effect. So if the synergistic effect is there, then only it can be patentable. Mere arrangement of or rearrangement of known devices, without these devices independently working, you cannot get a patent. So without, so these are, you have to show the dependency of these devices. If I combine two devices, like mobile having a torch, these are the two independent devices and they are independently functioning. If there is a dependency for the function, then you can get a patent. But if there is independent functioning, then you cannot be given a patent for that. So all to protect the farmers and gardeners. So any method of agriculture or horticulture is not patentable, but it is not applicable to the devices of the farming or agriculture. And to protect our doctors. So no method of treatment of human or animal is allowable. So you cannot get a patent for the development of any surgeries or any methods for the treatment, medicinal treatment of human or animal, whether it is a veterinarian or the doctors. In any, you can call any way, it is allopathy or homeopathic or Ayurvedic. So no methods of treatment can be patentable in India. But don't be discouraged. So all these methods you can get a patent in US or other jurisdictions like Australia. But in India, we have a restrictions through the Patents Act 1970. So you cannot get a patent for them. So any transgenic plant or animals, so no genetically modified plants or animals except microorganisms, you cannot get a patents in India. So it is not patentable. So for the animal or their parts, plant or their parts. So including the genetically modified animals or plants. So no patents for computer program per se. So softwares are not patentable in India. Software program, only you can get a copyright for them. So in India, but in US you can get a patents for the softwares. So any copyright, I will explain what is copyright and design. So in industrial designs, so any IPR you want to take it as a copyright or design, okay, but the same thing you cannot get a patent for them. A method of playing a game, including video game or any mental acts, whatever the acts we are doing by mind, so those are not patentable in India. A presentation of information, like today I am presenting on IPR in its protection in India. On this topic I am presenting. So this type of presentations you cannot get a patent in your name. So topography of ICs, there is a separate IPR called as SICLD. So that's why you will not get a topography of ICs as a patent because they are subject of the other. The last in section 3, that is any traditionally known things, or in effect if it is anything which is a traditional knowledge, so you cannot get patent because traditional knowledge is already in a public domain, one or the other form. May not be at one place it is published, but it is there in one or the other form. So that's why you won't get a patent for the traditional knowledge. Either it can be a oral knowledge or it can be a documented knowledge. But any traditional knowledge available in any community or in any person, so you cannot get a patent for that. So in non-patentability, again there is a one section, that is section 4, which says that all atomic energy related inventions are not patentable in India because it's a dangerous. So if any one comes up with an invention for nuclear bomb or atomic bomb, so it will be a dangerous to publish those. So that's why if any invention which is having radioisotopes like uranium, thorium, so these are not patentable in India. So you cannot get a patent for them in India. So these are that. So now, so you have invented any creation for a new product or process having inventive step and industrial applicability. 3 criteria you have, and you checked with the 3 A2P and section 4, it's not falling under any category. So then you are welcome to file a patent application. Now, the question before you is, what are the documents required to file a patent? So I just explained patentability requirements. What to be checked before coming to patent office? You need to check novelty of your product or process, inventive step and industrial applicability, and section 3, section 4. So if you are done with that, so what are the documents you need to file? So the documents, first and foremost, so form number 1, that is application form. So it's a simple 2 or 3 pages form. Here you need to give all the details of the applicant, inventor, and overall what is the address for service, what is the title of the invention, and some declarations along with that. So you need to make. It's a very easy form, the form number 1, where like So someone has enrolling it to the Sumandeep Vidyapeeth, they might have filled a form. It is the similar form only, form number 1. The second one, so that is form number 2, which is the most important one. That is, you can file in the provisional or complete. Say provisional means today I am starting my research. Still I have my idea, but I have not worked out with that invention. So you can just file a patent application as a provisional patent application in the form of form number 2, provisional. So that will also be protected, but the condition is that you within 12 months you need to file a complete specification. Provisional will never get a ideas, you can never get a patent for that. So once you've done a practicalities, then only it is eligible to file a get a patent. So provisionally idea can be filed with some description of your idea and manner of doing it, but without completion of the research with the details, you cannot get a patent for that. So provisional and there is a complete is must. So complete you have filed, so then only it will go for publication and it will be granted a patent after verifying it. Form number 3, statement of the foreign filing details. So this is also important form where all other countries you have filed a patent, you need to disclose to us. If you are saying I have filed so on X, Y, Z countries, so then you have to give information to us. That is one page form. And the fourth one, request for examination. This is form number 18. So this you can file either on the same day as form 1, form 2, form 3 you are filing, or you have time up to 48 months. That is 4 years time is given to file this form number 18. Whenever you want, you can file. That is, without form number 18, we will never examine your invention. So these are the 4 forms. So provisional and complete you can file, that I already said. So along with these forms, what you need to submit is the fees. How much fees you have to submit? So for example, natural persons, all the inventors, we treat them as a natural persons or any person by their name, given name, they are all natural persons. Startup companies, small entities, that is MSME or SMEs, or all educational institutes, for example, Sumandeep Vidyapeeth. So if they are all filing, so the fee is, applicable fee is 1,600 for the form number 1 and 4,000 for the form number 18. So if you, this fees is online filing, that is e-filing. If you file physically, that is offline mode, so then you need to pay 10% additional fee, because we have to again digitize the records which you submit in the offline mode. So online filing is preferred one. So there the fee is also reduction, 10% fee reduction will be there. So you can. So if you are not neither a natural person, startup or SME or that educational institute, then you need to pay the fee 8,000 for the form number 1 and 20,000 for the form number 18. So online filing, offline 10% additional. For all these fees 10% additional, you will be filing a fee. So for the 5,600 is the fees for the natural persons or educational institutes, or 28,000 for the other than these. So there is an option since 2016, patent office has made a amendments to the rules, so which will allow you expedited examination. If you are a startup company or small entity, or India, you have selected India as a ISA, you filed an international application and India is ISA in that, or all are natural persons in that, at least one woman applicant is there. So then our government department, state or central government departments, then they are eligible to file a expedited examination, that is form number 18A. And with additional fee. So 4,000 will become 8,000 for them. If the 4,000 is the pet category, then 8,000 it will be. And what is the advantage of this expedited examination? You will get a first examination report within 1 month. If any objections are there, we will examine and send within 1 month of Form 18A. And if no objections, after 6 months of it, publication, it will be granted. So quickest time you can get in a patent, but through the expedited is the 8 months. So now to analyze, I have made form number 1, 2, 3, and 18 to file a patent application. Am I eligible to file a patent? So who can file a patent? As per section 6 and section 134, any person, either alone or jointly, any person who is a true and inventor, first inventor. So all the inventors, primarily they are having their rights. So they are eligible to file a patent application. But it is governed by their own institute's IP policy. If Sumandeep Vidyapeeth is having IP policy, they are bound by that IP policy. So they have to take permission, whether it is to be transferred to the institute or they can directly file that. So here, by any person, assignee of that person can also file. Like inventors who has invented in the institute of Sumandeep Vidyapeeth, they can assign it to the Sumandeep Vidyapeeth. The assignee, that is Sumandeep Vidyapeeth, can be a applicant. Or legal representatives, legal heirs of a deceased person who has invented but not filed a patent application. So any legal heir of a deceased person, they can be a applicants. So where to file? If you are from Gujarat state, so then your jurisdiction falls under the Mumbai Patent Office. So if you are from southern states, that is Chennai, and if it is a northern, it is Delhi. And if any state which is not covered in these 3 offices, then it will be Kolkata is the patent offices. So totally in India, we have 4 patent offices situated in 4 metros. So there you can file a patent application. So if you are filing online, no need to worry, because it will be automatically, when you give a PIN code, it will be automatically takes up the jurisdiction. But if you are filing offline, then you need to send, where to send it, it should be sent correctly. If you are from Sumandeep Vidyapeeth, so then you need to send it to the Mumbai Patent Office. So it is jurisdiction based filing for the offline. For online, it is automatic. So once I file the form number 1, 2, 3, and 18, that is minimum forms 4 with a fee of that is 1,600 plus 4,000. How the application will be processed in the patent office? The first and foremost step for a patent office is to publish that application. There are 2 types of publication. That is, one is early publication. The another one is the 18-month publication. So early publication, if you are filing additional fee with a form 9, we will publish within 1 month. That is called as early publication. And if you are not filing form 9, then it will be normally 18 months is the from the priority or first date. It will be 18 months, 1.5 years we will take for the publication of invention. So once published, any person, anyone, irrespective of which country he is, he can give apposition called as pre-grant apposition. So he is having any ground for the grant of a opposition for the grant of a patent, he can file as a pre-grant opposition on form number 7A. And whether it is opposition is there or not, it will be examined. It will be by the examiner, and then controller will supervise that report, and the first examination report will be sent, and he will be given a time period of 6 months to reply that. It is extendable by another 3 months with an additional fee. So 6 plus 3 is the criteria. So you have to reply to the first examination report, and after that it will be meritorious, it will be granted, otherwise it will be given hearing with that. So after hearing, it will be decided whether merit is there or not. It will be grant or refusal. So after grant, again it will be published. So that publication is a post-grant publication. So after publication of that, any person interested can file a post-grant opposition. If they have objection, any person interested, they can object it as post-grant opposition. So in quickest time, it will be 8 months expedited route, and in normal route it will take little more than 2 years, approximately 27 months it will be for grant of a patent in normal route, and in expedited route, that is 8 months is the quickest period. So now that was the patent. So what is patent, and what is the subject matter which is patentable in India, and what are the requirements, patentability requirements, and the form requirements and fee requirements. So that ends the patent, one of the IPR, that is patent. Now moving on to the second, that is industrial designs. So what is industrial design? The features of shape, configuration, pattern or ornament, or composition of lines or color combinations, which are applied on 3-dimensional or 2-dimensional. It can be either 2-dimensional or it can be a 3-dimensional designs, or it can be a both forms. So they are called as industrial designs. In simple, it has a aesthetic look. Either it can be a shape, configuration, pattern or ornaments, anything which is attractive to the eyes of a human. So that is aesthetic look, so which will be called as a industrial designs. So what is the fee for filing a industrial design? It is 1,000 rupees for the individuals or small entity or the startups companies, and it is 4,000 for others. So you have only one form, that is form number 1. With a clause you can file it. So you with a 2 sets of representations. And how to make the representation? This is the scheme specimen sheet of a representation sheet. So here is the teapot, so which is have to represent in this 2-dimensional or 3-dimensional picture. You need to represent, and that will give you the industrial design. With 1,000 or 4,000 you can file it. The third one, intellectual property, which is very common IPR, is the trademark. What is trademark? It is a word, name, symbol or device which is used to trade goods in a marketplace. What that indicates? It indicates the source of the goods, from which origin. For example, if any car it is moving which is written with a TATA, then it will be a company is Tata's car, that is Tata company car. So like that, it will be indicates the source of the goods, who has manufactured that good. And advantage of this is it is distinguishes one manufacturer to other. So trademark is a word, name or symbol or a device. So it will be a distinguishing for the companies at the marketplace. So it will comes with a brand, whether it is a who has the manufacture of this. So it will be a reputation it gives. So like Bata, Tata, and there are service marks also, trademark and service mark. For example, DHL, Blue Dot. So these are the service marks of that companies, that service oriented companies. So it can be a invented words, it can be a numerals also, 1, 2, 3. It can be a combination of both numeral as well as words, arbitrary dictionary words. It can be marks, constituting three-dimensional designs. It can be on that as a trademark, and it can be even shapes or sound marks. So examples of this like McDonald's or Coca-Cola, this Adidas. So these are having some symbols as well as the words. So it can be a combination of word and symbols. It can be a simply symbols, or it can be a simply words also. So that will indicate the companies. The another fourth IPR, which is geographical indication of sources, GI. Geographical indications are place names used to identify the source of origin, from where it has originated, and quality or reputation of the goods. So it will give quality or reputation of the goods. So it can be, GI can be for the natural or artificial man-made one. Like Nagpur orange, it is a natural one. So like Ilkal sari or Dharwad peda, these are all the GIs which are given for the artificial goods. So what it is, it shows the characteristics of the products. And the main difference from the trademark and GI is the trademark can be obtained by person or companies, but GI can only be for the registered society or governments. GI is not a personal right. So GI can be only a societies, registered societies or governments, state or central, they can obtain in their name, but not the individuals. The fifth one, copyrights. What is copyrights and related rights? This is not a single right, copyright. It's a bundle of rights. What it provides a holder to restrict unauthorized copying of the creations. Whatever the creations you have done, there are several creations under copyright. The literary work or dramatic work or movies, music, painting, software. So this should not be copied. As it is, it should not be copied and sold. So that commercialization of that original work should be rights with the copyright holder. It's a by default right. Even you not worry about registering also. It gives some rights against others, even just publication also. So copyrights gives the against publication of or against copying of that work. So examples of this copyright: literary work under section 2 of Copyright Act 1957, which will be literary works, dramatic works, sound recording works, artistic works, that is paintings, musical works, composition of cinematographic films. All films nowadays, whatever released, so they will be after copyright only, they will generally release, because they will stop unauthorized or restrict others not to use their creations. So these are the subject matters of copyright. One dichotomy with reference to idea. So many people will ask, can I get a copyright for my idea? So abstract idea or ideas, no copyright can be obtained for the ideas. You cannot get a copyright for ideas. So ideas, when you express it, then only you can get any form of IPR. So what is the time periods for the copyright? For literary or dramatic and artistic musical works, it's a life of author or creator plus 60 years after death of a author. So even after 60 years also you have, that is up to 60 years after death, it will be protected in the name of the author. So for cinematographic film and sound recording, it is 60 years from the date of publication. All the broadcast reproduction rights like television, that serials or the TV rights for this matches, cricket matches, all these broadcasting rights will be 25 years. If it is published in this year, from next year onwards, it will be 25 years. So performance rights, any performance rights, they are 50 years from the year following the year in which it is performed. So if in 2022 it is performed, next year onwards it will be calculated with the 50 years. So these are the time periods which are there for different works, different time periods. So it's a simple one. You can file a copyright with a prescribed fee as per the schedule 2. The fee for literary, dramatic, artistic and musical work, it is 500 rupees, and it is the artistic work which is to be sticked onto the others, that is any articles you are making this to fixed on the goods, then it will be 2000 rupees for the application. And sir, sound recording 2000 rupees application fee, and all the cinematographic films whatever the released every Friday, so they will be registering in the Copyright Office with a 5,000 rupees. So the last in my topic is the semiconductor integrated circuits layout design, that is SICLD. So this is not patentable in patent. As I said already, topography of ICs is not patentable because there is a separate IP called as SICLD, semiconductor integrated circuit layout design. So what is this? Any layout design you have made with semiconductors, so you can protect it after testing of it. This is a little bit different from the other IPRs. Other IPRs on a paper you will get it without any demonstration, but here with the semiconductor integrated circuit, so you have to demonstrate what you have developed as a novel product. So you want to develop, you have developed this semiconductor integrated circuit, so you will get a product as a that special IPR SICLD, but you have to demonstrate it. After checking it, then it will be given a SICLD protection. So now if you want see all the 5 IPRs in one, for example, you take, this is not for advertisement, this, so you see LED display, there is a special type of display technology that is patentable. And design of this laptop, so this laptop design can be a industrial design. And the off-cut apple, so you can see that it is a apple, that is a company's trademark, and it can be a copyrightable. The user manual of this laptop is copyright protected, and the inside circuits, whatever they are using circuit for functioning of this laptop, it is all protected as a SICLD. So we have seen this product commonly in market, so maybe might be several people might be using either. So these are all protected ones, so everything is protected in this. So there is a patent, there is a design, there is a trademark, there is a copyright, and SICLD. All are protected in throughout the globe. Most of the countries, they have got a registered or granted with these technologies. So these are the different things. So if you want to know how much time I can have a protection, patents is for the 20 years. And there is nothing called as a global patent or global IP. So every individual country, sovereign country grants, then only you will get a that according to their laws. Designs 10 years plus 5 years extendable, that is 15 years. Trademarks, there is no time limit, indefinitely, but every 10 years you have to pay renewal fee. But in patents, you every third year onwards you have to pay up to 20 years renewal fee. Then only it is enforcement. Otherwise, it will cease. So here trademark every 10 years you have to pay renewal fee. GI is also, it is indefinite period, but every 10 years you need to pay renewal fee. So copyright, I already explained, that is life of plus author plus 60 years, or some are 25 years, some are 50 years, So like that, it is protectable for different form of work is protectable for the different. So all IPRs except GI, you can individuals can file or companies can file. Only GI, there is a requirement of a society or government can only file. And all IP rights are territorial in nature. So with this explanation of different forms of IPR, right from patent to SICLD. So I hope I have given brief introduction of these and this all. So what is my suggestion? So one can take the advantage or benefit of this system, patent system and IPRs, different IPRs. You have created anything, you have a company, you can protect them, your names as a trademarks. You have technology, you can protect them as patent. You have aesthetic look creations, you protect them as industrial designs. By using organized research and development activities, capture global market judiciously and earn profits. So by doing all the researchers, they are doing innovations and protections. So India will be moving ahead in the global innovation index. So that is what our aim. We need to protect our researchers should protect more and more so that we will be having at goal. So overall it will be, so for students, those who are interested, so if anyone wants to come to patent office either in the MSc with the different science subjects or BE or BTech, so with the exam they can write, or if anyone any degree, it can be BDS or any medical degrees or any BSc, all they can be if they are citizen of India, having 21 years, having a science or engineering degree, they can register with us as a patent agent. If they are interested, they can work after passing the exam. This year only in the May we conducted, every 2 years there will be a patent agent exams. If anyone interested for the IPR career, so they can, because they can work in the revocation proceedings, infringement suits and other legal proceedings in courts. So if someone wants to learn more on IPR or patent, so they can visit this IP India. This is patent office or CG office website, ipindia.nic.in, WIPO.in, that is World Intellectual Property.int International, European Patent Organization.org, and USPTO, United States Patent and Trademark.gov. So these are some websites. Even through Google also, lot of information is available. So you can go and get the information. So, and it will be whatever your creations, you can protect it. So I thank all for this hearing given to me, and I thank recently for the Sumandeep Vidyapeeth and specifically IQAC team and its director, Dr. Punacha sir, giving me this opportunity to share my information with you all. So thank you all. If any questions, I welcome, so we can have a discussion on that. So thank you, sir.
Yes. Sir, it was a very nice presentation. We got to learn so much. Anyone has any doubts, you can please ask, sir.
Yeah. Good morning, sir.
Yeah, good morning, sir.
Yeah, sir, myself, Dr. Tejas Shah, sir.
Yes, sir.
Sir, very nice, informative talk you have delivered, and we are very much thankful to you.
Thank you, sir.
Sir, recently I came across some of the queries regarding, sir, republication of the research article in the form of book, chapter, or book. Sir, whether it should be allowed or it should not be allowed, because once your research article has been published, whether it should be again republished in the form of the same content, the same information which they already published in the form of original article, can it be republished in the form of a book chapter?
So you were only published the article, sir, in your as a author?
Sorry, sir.
You only published that research article, sir, in the any journal?
No, sir. I received from some of the book publisher email. I got email that your particular research article has been selected to be published as a book chapter in so and so title book. And I have
Okay.
inquired and asked my seniors and take the guidance from the other senior professors, and they suggest that do not do such practice. It is not allowed,
Okay.
ideally, because they again
No,
publish the same thing, the same content, no any extraction or the content of that particular article,
okay.
no any change,
No.
sir, no any change.
As far as the copyright is concerned, so you are not violating unless, see, you are the author in the journal and you have a right to publish at one place or at many other places. Unless
Okay.
those other earlier publications restrict you. You have a MOU with them. So you say that you are not publishing anywhere else. So then
Okay.
you are bound by that. So if you have not made any commitment to the earlier publisher, you have every right to publish in more than one. So like I say, even some of the journals which we are publishing in a patent office journal, patent document. So many
Yes.
people after patent filing, they publish in the peer reviewed journals also.
Yes, sir.
So same content only.
Yes, sir. Or
So
one
it
more
doesn't, you are, see, since you are publishing at one place, you will not lose the right of on that unless you are bound by some agreement with them. So I
Yes.
think you have every right to publish at more than one places, sir.
Okay, sir. And one more thing, sir. We usually, when we send our articles to one reputed journal for publication, they initially seek the copyright form submission. Okay, so we hand over the
Okay.
copyright to the publisher of that particular journal, editor-in-chief, or their union, we can say, or association. So when again we want to republish the same article, again we have to take the permission of whatever copyright form that we have already submitted.
No, you have any foundation, sir, for that. See, if you are making any agreement with that, the earlier first published one, then only
Okay.
you comes the permission and all this.
Okay, sir. Right, sir.
I think what is the content in the agreement that matters, sir. I think what
Yes,
Yes,
sir.
sir.
the agreement
Yes.
matters.
Yes, sir. Thank you, sir. Thank you very much, sir. Thank you.
Yeah, thank you.
Sir, I was wondering if something is patented or registered in some other country, and if someone does a minor modification and comes and registers in India or in a different country, so is there a system for you where you can find out these things?
Yeah, so it's a, you are talking on patent only, sir, minor modifications.
Yeah, sir.
So we receive many things. See, it's our duty is to look into that whether it is copied from anywhere. We first and foremost we check in all the databases. We have a procured that searchable databases. That is a paid journal database, sir, either Orbit or Questel. So with the keyword and international patent classifications and CPC, that is all these things we use. We try to extract that from earlier whatever this information on this product or process.
Okay.
So we correlate with that. Even the minor modifications also patentable if they are advantage over that.
Okay.
As it is, if it is same, it's not novel. It will not be grantable, sir. It's not patentable.
I have a system of identifying across the
Yes,
world.
sir.
Yeah.
That is the examination. Ours.
Yes, sir.
Mainly our examiner and controller's duty is that only.
Okay. Yes.
Yes.
Anyone else has any doubt?
Yeah, I have one question, sir.
Yes, sir.
Suppose in India, we are applying for the patent, and if we want to go for the other countries like Spanish, Japanese, and all, so for
Yeah.
that also, we have to do it separately. How it is?
Yes, sir. Actually, I did not cover in today's topic. I thought it will be more for all. So going out abroad, so there are routes, sir. There is a conventional route that is bound by the international treaty, that is Paris Convention Treaty. And there is an international application also you can make, that is under the Patent Cooperation Treaty. So as good as in Patent Cooperation Treaty, there are more than 152 countries are there, member countries. So you are filing in India as an international application. There are either you can directly file international application or first file in India, and within 1 year you are allowed to file an international, make an international application, that application, and that as good as you have filed in 161, around 152 countries on the same day. That is the international route. So after that, you will be given to go individual countries within 30. Some countries are allowing 30 months, or some countries 31 months. So you have to choose that country where your commercial interest or business partner serves there. So you can go and file a patent. So that will be valid till 30 or 31 months. The time given is huge because it gives more than 2.5 years. Because you need a more time to evaluate and come up with the strategy to file in some other countries. So that is what we call it as a PCT, international application, and filing a national application. So in crux, within 1 year, you need to make an international application. That can be done either in Mumbai or Delhi or Chennai, or the online also you can file that international application. So there is a fee. There you need to file one international filing fee and the international search authority fee. So its international search authority fee is 10,000 rupees in Indian rupee, and that is international filing fee in dollar terms. I think around it will be, so maybe around $150 or so it will come.
So, sir, during the initial application only we have to do the payment?
No, sir. 1 year time is there. Local application you can file. 12 months time is given to make a, whether you want to file an international application or not, you can take a time to decide on that within 1 year.
Okay, sir.
Yeah.
Hello.
Yes, sir.
Hello, good evening, sir. Good afternoon, sir.
Good afternoon.
Sir, the lecture was excellent. Sir, now I think that patent publications, I think it's taking only 2 months. Recent one.
Yes.
It is previously it used to take around 8 months or 15 months or 12 months. Now, recently we got from our AIME Dental College publication that patent publication, it has taken only 2 months. I think the duration has been reduced, sir, I feel.
Yes, sir. Processing time, because the act has not changed, but only thing is that we are processing quickly because we are now receiving 90% applications online only. Earlier,
Okay.
what used to be in the offline, that has to be digitized and OCR format and then extract it, we used to get published. So now we are getting almost all applications in the online mode. So even within 1 week we are publishing, sir. Form 9 is filed means within 1 week you will get a publication. Monday filed means Friday you may see in the journal.
Okay.
So quick enough in the processing because of the digitization.
Digitalization. Okay.
Yes, sir.
Okay. Thank you, sir. Thank you.
Thank you.
Good
So one
afternoon.
question is that, can I take on that? Do we need to get the notarized digital signature done for design registration? It's notarized or digital signature is DSC. It is given by some agencies, sir. Like for patents, so you will get from the either eMudra or TCS is there, Encode Solutions. So you will get class 3 digital signature is sufficient for filing a patent or design online mode. So it is sufficient. Notarization legally it is not required. It's only signature certificate online. One pen drive will be given. You have to put that signature while filing uploading the documents onto the website. Yes, sir. Please go ahead, sir.
Sir, good afternoon.
Yeah,
Thank you, Dr. Gowda, for the very nice and very informative deliberation. It was really very informative. Sir, I am from Department of Management. I just wanted to know for my students and faculty members that apart from copyright, what is the scope for management? Whatever they used to do in the research form. Is there any other application apart from copyright, sir?
Yes, sir. Even see, management persons will play a lot role in the IP management.
Okay.
See, they are the most required or wanted persons in the IP management. See, it's only that researcher, science person can do the research and get a registration. That's all there comes. See, now they have to commercialize. So commercialize in the marketplace, they have to find a suitable person who is all working with that technology, how it will be commercialized, and you have to find a person for them. And IP evaluation, this is the emerging field in India. That is the what is the value of a patent, trademark, or any other things in the per year and for 20 years. It's a IP evaluation. It's a great work, because last year when I went to learn this one of the diploma course in Denmark, so there the management persons, they taught us a lot how the IP evaluation. There is a different course, how a market looks for the technologies.
Okay.
It's not easy that how next 5 years will be for the technologies, like what we are witnessing around us, the online platforms. So it will be a different ball game. So there, a science person may not know of all these things. To be frank, I was not knowing those all things. I learned a lot. So this commercialization and IP management will be a great task with us, with the management persons.
Okay. Thank you, sir. Thank you. Second thing is, sir, I was very happy to know the example you have shared of the Coca-Cola with that round ring patent. So
Yeah.
I was just curious to know, like the same technology is being used, that patented one, in the other companies as well. Like you take example of Amul or any other Kisan like that. So do they take permission from Coca-Cola to use this and then pay a royalty to them as well?
And that is what, sir. See, almost this what I put a ring pull can. So it is maybe around 40 or 50 years back, the research. This is
okay.
See, and patent is having a period of 20 years only. If it is granted in every country, so it will be a 20 years from the date of filing. After 20 years, anyone can use freely for the commercialization. So now it is no more in value, that valid enforceable right for that ring pull can.
Okay.
So that's why anyone, whether it is Amul is users or for oil tins also, we'll see with that. So no one is bound by that enforceable right. That is the advantage for the society.
During that 20 years period,
the enforceable right.
Okay. So during that 20 years period, if somebody use it, then they have to pay royalty to the
definitely.
the
Otherwise, he will file a suit in a civil court, so that he will be bound by that. So if the damages is awarded, so you have to pay the damages.
Okay. Okay. Thank you very much, sir. Thank you.
Thank you. Thank you. Please.
Yes, I think all the doubts are clear now. Thank you, sir. Thank you, Sharanagowda, sir. It was a very informative and eye-opening things in many areas, in IPR areas for the participants.
Thank you, sir, for this opportunity.
And sir, hoping in coming days also we'll have one more session, right? This we have not included students. We'll plan and I will let you know, sir. Thank you so much.
Sure, sir. Definitely will be a part of that. Thank you, sir. Thank you. Thank you all.
We'll be breaking for the lunch. After lunch, we'll continue with the session.
Yeah. Sir, can I leave?
Yes, sir. Yes, sir. Sure.
Thank you.